that have been doing, the father has been denied a chance to do DNA on the child, but he's also being forced to pay child support for a child that he cannot prove that it's his. So it's just a full breath of tailwind. And let's dive into the video so we can really see what's going on. Who's in the right? Is it the father? Is it the mother? Let's play.
The father has some reasons that he does want to do the DNA.
All right, sir. Tell me briefly here, what was the date of your marriage?
I was married on the 24th of April, 2014.
That was April 24th, 2014.
Yes,
Okay,
sir.
when was this child born?
On January 24th, 2019.
Okay. And you haven't filed for divorce since 2014?
Yeah, I haven't filed for divorce, but right now I'm considering filing for divorce. I've already put up for divorce.
Okay. Why are you asking for a DNA test for a child that was born during your marriage? And it's already been 4 years since the child was here.
Yeah, thank you for that question. I had no issue with my wife. We had a child, Malachi, who is healthy and growing. And all of a sudden, I got a notice from Attorney General of Texas that concerning child support. Can you hear me properly?
Yes, I can hear you.
Thank you. So I called my wife. Actually, I was like, what's going on? Look at the notice I got. She said, no, it wasn't you that I was trying to put on child support. Who? This is my name right here. She said, Sam. Who is Sam and why has Sam got to do with child support and Malachi? She said that she think that Sam is the father of Malachi. I mean, it is.
When was this conversation, sir?
This conversation was sometime early this year.
Okay. Does Malachi call you his father?
Of course.
When did y'all separate?
We have not separated, but the fact is, because of job, we're still married. Because of job, I'm here in Texas.
Okay, I don't understand that. And you live in a different state, so you're obviously separated. When did you move away, or when did you move away?
Okay, I was living in Louisiana. I moved down here sometime 2020 due to my job.
Okay, you've been in Texas since 2020?
Yes, sir.
And she's been in Louisiana since then?
Yes.
Have you had a relationship with the child?
Of course, I go often to visit them. I visit them. I go to Louisiana to see them.
How often do you go?
I go there basically like once a month. Sometimes it varies because of I'm a adjuster. I'm an independent adjuster. Sometimes I go different states to work, but I go there anytime I'm back in Texas to see them.
And when you go there, do you does Malachi you hold out to Malachi that you're his father?
Yes, sir.
Even after the conversation you had with her a year ago?
Sorry?
Even after the conversation you had with the mother?
The conversation is not a year ago, so sometime early this year. Yeah, I go there to see them, and I treat him as my son.
Okay, well, it's September, almost October. You say you go visit once a month. That means you probably would have visited 8 or 9 times this year, if that's true. So 8 or 9 times, have you represented that you're his father?
I can't basically say 8 or 9 times because I've been out of state for like 4 months. But when I came back, I went and saw them like 2 weeks.
So 2 weeks ago, you went to visit?
Yes, sir.
Did you represent that you were his father?
Of course I do.
Okay. Why would you do that if you're not sure if you're the father?
Sorry?
Why would you represent yourself as his father if you don't know for sure if you're his father?
Because ever since he was born as my son, so I have no doubt, except when she said that. But I'm still doing what I'm supposed to do as a father.
Not exactly, because what you're asking for me to do today is you're basically saying today, or who we talked to earlier today, that you have doubts that you're the father and you don't want to be Malachi's father. You want to do DNA tests to show that you're not the father, so that you don't have to support your child or
No,
this child, and that you
uh,
don't have any visitation rights with this child because you're denying that you're the biological father.
no, that's not what I'm saying. I said Malachi is my son. I'm not denying that he's not my son, but my wife put someone else's name to support her as regards Malachi. That brings very big question in my ear. I'm getting this notice that my wife put me on child support. So when I asked my wife, she said, no, it's not you, it's Sam. I said, who is Sam?
I know I've already heard this before, sir. The
Okay.
paperwork that the Attorney General's office received from the mother through Louisiana, on that paperwork, it does not say that you are not the father. We can point it out and show it to you on the screen if you want. It says on there that you are the father. It doesn't say anything else about her having doubts or anything like that. So you're telling me what she do, stuff that I can't ask her about because she's not here because of the kind of case that it is. That doesn't necessarily mean that it's true. As far as what we understand, based on what the other state has asked us to do, the information they're getting from the mother is she's naming you as the father, not anybody else. So again, the only reason we would do DNA is if you're denying you're the father. If you're the father, then we're looking to do a child support order. I'm not understanding again why you're denying paternity or wanting DNA tests.
Yeah, what I'm trying to make you to understand here is if my wife should put someone's name as the father of Malachi.
You understanding that it's not in any paperwork that we have. You understand that?
Yeah, I understand that.
Okay.
Well, that's why I'm pleading to this honorable court to please, if that is the case, let us determine who actually and what my wife is. If you guys can, if the court can ask her who is Sam, and not only that, if the court can give me the opportunity to clear my doubt by going for paternity tests.
Why haven't you done that already? You've had for
I
4
don't think
years.
I was thinking that I don't have the jurisdiction or the legal right to do that without the court asking me to do, because I didn't see anything. I never saw it coming, because this notice I got just like a shock to me.
I don't understand how it's a shock if it's your child. You have an obligation to financially support your child, whether it be through a child support order or not through a child support order. The only thing that changes now they want a child support order.
I do support my child.
Okay, well, then you're going to continue to support your child. I can't grant you DNA tests. It's been a long time. The child's for over 4 years old now. You're married to the mother. I mean, you're telling me information that's not consistent with what the mother filed in her testimony. She filed general testimony as if she was here, saying that you are the father, not anybody else, you. She could have put in there that you weren't the father or whatever else she could have said in there, but it doesn't say that. She names you as the father. In addition to that, she named the child has your last name. There's really no doubt for me as far as what the mother has put in as far as the official paperwork. I'm not saying your conversation didn't take place, but there's nothing I have that can show me that. And then you continuously keep saying it's my child. Well, I mean, that's kind of goes against what we're saying here. We cannot do DNA tests for everybody under every circumstance. Now, if you were not married to the mother and you want a DNA test, then definitely we would do that because there's no legal finding. But under the state of Texas law, if you're married to the mother and you have a child with the mother, or the mother has a child, your wife has a child, you're presumed to be the legal father unless you do something actively to change that. If you don't do anything to actively change it, then that's the way it is, which usually the way it's supposed to work, which I know people don't do, is they get divorced. And then the divorce says there was a child born during the marriage, but it's not the husband's child. That clears that up for us. But And I understand your situation is a little different, maybe that you say that y'all are separated or not separated. I guess y'all aren't living together, so haven't lived together for a long time. I don't know what her opinion is if it's different. She may say that y'all are not together. But either way, we're kind of stuck here. So I can't grant you DNA testing based on the circumstances of your case. Ms. Correa, do y'all want to go back to negotiate, or you want to go ahead for the hearing?
He can go back and negotiate.
Okay. All right. I'm going to leave you some time so you can go back to talk to somebody about your case, to talk about the numbers and see if you agree to those. I'm not going to do DNA testing, sir. So we are doing a child support order today. I just don't know the exact details right now. Okay.
Can I ask a question?
I think I already answered it.
No, I just want to ask it, just one question.
What's your question, sir?
All right, thank you. Do I have right to clear my doubt by going to do DNA test myself and present it, if the result comes out, to present it to this court?
You always have right to do DNA tests. You can do that anytime you want to, but you can't make a court do it for you, which is what you're asking me to do here. That probably will not clear your case unless you do that within a short time. So within the next 30 days that you appeal this decision that we do today and you have your DNA test done. If you don't do it outside that time period, you're going to be paying child support for the next 14 years. So this is, again, you've had 4 years to do a DNA test. It's not like I'm trying to give you a 30-day deadline, but you've had 4 years. You haven't done anything. And even though you say you allege that she told you in maybe January of this year, you've had 8 months. You've visited with the child over the last 8 months. Having a child support order doesn't change anything. You've had the ability to do DNA tests all this time. If it were me, if my wife told me in January that you might not be the father, I would have quickly run to a DNA test center to find out if I was the father or not. You did not quickly run, and now we're here. So definitely you can, but you have a time limit with the court as far as whether or not you have to can get out of your child support order. You'll need to talk to an attorney about that. I cannot give you legal advice other than once that 30 days expire after this order is done today, your time to appeal it will be very limited, like almost not going to happen. Okay, so understand that.
Okay.
Right, let me leave you so that you can talk to somebody with the AG's office about the numbers, and then they'll send you back to see me later to talk to you more about whether you agreed to those numbers or not. All right, just hang on just for a minute, sir. All right, so remember you're still under oath. We had the hearing earlier this morning about DNA testing, which was denied. Mr. Tiggio, why don't you tell us what the amounts and just kind of recite to us what the amounts are, and then we'll ask him if he is in agreement to that or not.
Okay, sir, for the monthly child support that we've calculated for Mr. Oduezi, it would be $661 beginning in October of this year, October 2023. And for retro child support in this matter, it would be $100 per month starting October. The NCP was given credit for $9,600 for past support, as he told me he's paid $200 a month to the mother. And then for medical, starting in October, will be $200 a month and court costs as billed. But I didn't get a chance to read that out to him as the final.
I'm sorry. What was the retroactive judgment after the credit?
$100 a month.
Okay, well, no, I'm saying that's his monthly payment on it. Is there a judgment that you're requesting?
Oh, I'm sorry. The judgment was $11,898.
All right, Mr. Oduezi, first on the child support, we'll kind of go by one here. They calculated based on your wages that your child support should be $661 a month. Do you have any, do you agree to that, or are you objecting to that?
Your Honor, I'm objecting to that.
Okay. How much do you earn, sir?
I don't have a regular job. I'm an adjuster, so I go to work anytime I'm deployed. Right now.
How long have you been at your current job?
How
long have you been at your current job?
Right now, I I was there for 4 months, but right now I'm not doing anything.
That wasn't my question. My question was, how long have you been doing the adjusting or whatever you're doing now? How long have you been in that field?
I've been there since April last year.
Okay. You had a completely different job before that?
Yes, Your Honor.
In your previous job, were you making more money or less money?
Less money.
Okay. So how did they, in the last 4 months, how much have you earned?
Last 4 months,
Yes, you said you started working there, I think 4 months ago, right?
yeah.
Okay, so how much have you earned in the last 4 months?
I can't specifically say it like in the figure, but it is kind of less than 30,000.
You made $30,000 in 4 months?
Less than.
Okay. And that's just over a 4-month period, not over the last 9 months?
Yes, Your Honor.
So when you moved to Dallas area, you're working at a different job in January?
Yes, Your Honor.
So if I divide 30,000 by 4 months, that's about $7,500 of monthly income that would average out to. You believe that number is incorrect?
It's me?
Yes, you.
Yeah, something like that.
Okay. Is that if you, what was the calculated gross wages y'all had?
10,260, I'm sorry, $11,237.
As much as you're able, do you know how you came up with that number?
He told me first we used 50,000, which is what he made on his W-2 for last year, but then in the year before he said he made between 20 and 30,000. So I added those numbers together and then divided by 12 to get kind of an average.
I don't understand the average of. Okay, so previously you made 20,000 a year, then 30,000 a year, then 50,000 a year. And then you average those together and that came out to an average of $11,237 a month.
Hold on, let me just look at my calculations because I roll over the place now. Your Honor, can I ask Ms. Kendra Hood for assistance because she was helping me with the calculations in the private room? I'm just going to send her a message on team really fast.
Judge, I'm here. I believe we're going to have to go back to the breakout room briefly, if you don't mind.
Okay, just don't take too long. It's our
I
last.
won't.
It's not allowing us to go to breakout rooms.
Okay, Mr. Dwezzy's back here. Are you ready?
Yes, Your Honor. So I believe the hearing had already started. Is that correct?
We did have a hearing earlier this morning. Mr. Odwezi wanted DNA testing. We went through a long hearing on that. I denied his request for DNA testing, and then we went back to negotiate to talk about the amounts for support.
Okay, thank you.
And then we did have a second hearing, I guess, or second part, I guess you could say. Child support was proposed at $661. Retroactive judgment requested of $11,898 with a payment of $100 a month. Medical support of $200 a month. We had just gotten stuck on the first one, which was child support proposed of $661. Mr. Dwezzy said he made $30,000 in the last 4-month period. So I was trying to figure out from the Attorney General's office where we had come up with the gross wages, I think of $11,237.
Yes, Your Honor, I can take over from here if that's fine with you.
Okay.
All right, thank you. All right, sir. So the state calculated a proposed gross income of $4,166.66. And that is based off of your 2022 income. Is that correct?
How do you come up with that number?
Okay, in 2022, sir, does your W-2 reflect that your yearly income was $50,000?
2022?
Yes.
I hope so, because I'm not with it here.
Okay, do you have a copy of it, sir?
I don't know where I can find it here right now, because I don't have it right now.
Okay, and what type of work were you actually doing in 2022?
I'm an insurance adjuster, auto.
Okay, are you doing the same type of work now?
That is what I do when I get deployment, but right now I'm not deployed.
Okay, what do you mean when you say deployed?
Okay, what I mean is I'm a kind of independent adjuster. So when there is work, I'll be called for a certain time, a certain period, like 3-4 months. It depends on how it lasts. So when it is done, so I'll be out of job until I get another one.
Okay, so but in 2022, you did receive a W-2, is that correct?
Yes, ma'am.
Okay, so you are not a 1099 employee?
I'm not a 1099 employee.
Okay, all right. And so, and earlier, sir, did you testify that you, over the past 4 months, that you earned approximately $30,000 in your new job as an adjuster?
That's what I told you on.
Okay. And so today, are you asking the court to set your child support based off of the $30,000 that you earned over 4 months?
No.
Are you asking the court to set your support based off of your 2022 income of $50,000 per year?
Yes, ma'am.
Do you believe that by the end of 2023 that your average income will be approximately $4,166 a month?
I believe so.
All right. And so, sir, do you have access to private health insurance for the child in this case?
Yeah, he is on Medicaid.
Okay. And so you understand the state is asking the court to order the custodial parent to continue coverage of the child through the government medical plan. Is that correct?
Can you explain that more to me, please?
The state is just asking that the child's coverage continue through the government medical plan in the other state. Do you agree with that?
Yes.
The state is requesting that you be ordered to reimburse the state for the government medical plan at the rate of $200 per month beginning October 1st of 2023. Do you agree with that?
Is there any way it can be less than that?
You understand that $200 is already less than the 9% that the state can request in this case.
Okay.
Okay, so do you agree to the $200 per month?
I do.
All
But
right.
if I don't agree, do I have any option?
Yes, you can ask the court to lower it. Yes, sir.
Yes, I want to ask the honorable court to please lower it.
All right, sir, the state has also calculated a proposed child support amount of $661 per month beginning October 1st, 2023. Do you agree with that amount?
If the honorable court can as well lower it, that would be good for me.
All right, thank you, sir. Sir, the other state has requested that you be ordered to pay retroactive child support from January 2019 through today's date. The state has calculated the retroactive period from September 1st of 2019 through today's date. Now, have you provided any financial support for your child directly to the mother?
Yes, yes, I do.
And how much would you say you provided?
I do approximately, as I told you, between 200 and 250, you know.
Okay, thank you. All right, sir. And from September 2019 through April 2022, which is when you were working a different job, I think you mentioned your income was between 20,000 and 25,000 per year.
Yes, ma'am.
Now, the state calculated a retroactive child support judgment using $22,500 from September 2019 through April of 2022. Is that what you're asking the court to do as well?
Can you please say that again?
Okay, so from September 2019 through April of 2022, you were earning approximately $1,875 a month, right? Does it sound about right?
Yes.
Okay. So, sir, the state has calculated a retroactive child support amount before any credit is given in the amount of $21,498. You understand that, correct?
Right.
Now, if the court were to grant your request for credit of $200 per month for 48 months, that would leave $11,898 in retroactive support due to the mother. Do you agree with that?
I do.
And do you agree to pay that judgment out at the rate of $100 per month beginning October 1st, 2020?
If that's the calculation, but if it can be lowered, I'll be okay with that.
Okay. And so finally, the state is requesting that the court order you to pay court costs as billed, okay?
Courthouse fee.
Yes, court fees. Yes.
I don't know about that.
Okay. Pass the witness, Your Honor.
All right, remember from the very beginning, I asked you to tell the truth about your income. I think what the state has calculated is correct based on your income. I cannot set it on some arbitrary amount just because you don't like the child support. Medical support is set at a reasonable amount at $200 a month. I'm gonna grant that for medical support. If you want to find private insurance that might be cheaper, go ahead, give it a try. If you can find private insurance is cheaper, enroll the children on your insurance, and then show the mom and the Attorney General's office a copy of your proof of enrollment in the insurance. If you don't do that, you're going to pay $200 a month for the child to be on government medical. The child support they calculated, I think, is fair based on what you earned. It's $661 a month based on your earnings from 2022. Obviously, I don't know what you're going to make for 2023. Averaging it out over the 2022 period should give us somewhat close to what you're going to probably make this year, but I don't know. You could make more, you could make less. We try to average it out so that it's not at a high amount or a low amount. So I think 661 is correct. You owe a difference in the arrears. You didn't pay enough money. You should have paid more than 200 or 250. And honestly, I don't really believe some of what you're saying because you've given me a lot of different stories today, which kind of leads me to believe that sometimes you're not telling me all the truth. I'm going to grant a judgment of $11,898, pay about $100 a month until you pay that in full. If you pay that judgment off, you don't have to pay the additional $100 a month. But if you don't have the ability to do that, then you're going to owe that until you pay off the balance. Court costs are assessed against you, Mr. Dwezzi. The Attorney General, the county may send you a bill for the court costs. The Attorney General's office will draft an order based on my ruling today. They will email you a copy, and then you can begin paying the payments through the Texas Child Support Office. Very important that you understand that your payments must be paid through the Texas Child Support Office. The Texas Child Support Office will then send that money to the Louisiana Child Support Office and then to the mother. It will take a while for that to get all the way around, but you need to have that happen that way because you need proof of the payments that you've made. If you make payments directly to the mother or to Louisiana, or leave out one of the states, then you're going to wind up with back child support that you owe even more than you know today because they're not going to have any proof that you made a payment. So do not make payments directly to the mother. Any payments in the future should be paid through the child support office. If you are a W-2 employee, you have a duty to inform the Attorney General's office where you're employed. So if you change companies, you need to let them know so they can send out a new withholding order. So then they can just take it out of your check and you don't have to worry about it. You are done with court, Mr. Dwezzi. You have 30 days you have 7 days to file a de novo appeal, 30 days total to file a motion for new trial if you have any new evidence. But otherwise, this is the order that I'm making today based on the testimony and evidence that was presented to me today. You are done with court and are excused. You can press leave on the Zoom to exit out.
Okay, so you basically see how it went for the dad. The judge didn't believe him. And in hindsight, not only was he denied child support, but he was also encouraged to not take, well, he was told to take the DNA test and he got 30 days. If not, he'll be paying child support for the next 14 days. And I agree with the judge in certain aspects. If you feel that the mom lied to you, why are you hesitating and waiting around for this to come to fruition? You need to get on this now. But nevertheless, this is Antonio, Team Tiggio. Please like, comment, subscribe. as we'll be coming to you with more videos in the future. And once again, we'll see you in the next video.